Y'all fasten your sofa seatbelts because we're going to get to see the hearings. I just wanted to do a quick update on the hearing that took place today about allowing the preliminary hearings to be broadcast. Players that were in the hearing today was Judge Eaton's, Mark Means representing Lori Vallow Daybell. We'll get to that in a minute. And John Pryor's representing Chad Daybell. And then we had Stephen Wright, who was representing the media, and then Rob Wood, of course, who was the one that put the objection up, saying, look, we don't need to broadcast this stuff. So first things first, I thought it was very interesting that Judge Eaton was like, Lori is now going by Lori Daybell, and it just sends shivers down my spine. Now, Chad was there as well. He was sitting next to John Pryor, and I swear to God, every picture of them looks exactly the same. John just has this scowl on his face, and Chad just has this, eternal resting bitch face that just never goes anywhere. I mean, it's just bizarre to me, but anyways, he was there, Lori was not there, and so I thought that it was interesting we got another glimpse at Chad after July 22nd. So because this was Mr. Rob Wood's motion, his objection, whatever, he was allowed to go first and speak, and he basically just reiterated what he said in there. He's like, look, this is all about preserving a fair trial here. I want to make sure that Daybell has, a fair trial, that this is not tainted. The jury, is not tainted by us broadcasting this. This is very, salacious stuff. It's already been put out there a lot, and it's just going to make jury selection that much more difficult. Now, he does say, look, I've never given interviews. I've never gone in public and said anything about this stuff. I thought this was interesting of him to bring up because one of the counterpoints to Mark Means and John Pryor was saying, look, not specifically Rob Wood, but, members of law enforcement and people like this have made public statements regarding this case. So, hey, they're out there doing that, but we're not doing it. So it's like all the attorneys are like, okay, look, we're all not doing the same thing. Rob Wood is like, look, I'm not asking for a closed or sealed hearing. We're still going to have the audio. We're still going to have the transcripts. We're still going to have still photography. It's just the live broadcasting that I'm about. Now, next up, John Pryor goes, and again, he has his scowl. He says that, Rob Wood's thing is around avoiding a public display of this whole situation. And then he goes down a history lesson, and he's like, this went back to our founding fathers and the documents that they came up with, that the public has a right to these trials. And he's like, look, I really felt like the court really took their time with this decision. I felt like the original decision was the right decision, which was allowing it to be broadcast. And so he's, doing a little kissy buddy thing, but, he's like, look, we already got this right. We don't need to go against what's already been put out there. At the end of it, he's like, look, there's two options here. We can either open the doors and let the public come in and have their right to a transparent trial and my client's right to, a fair trial. But we can't do that with COVID. So the other option is, I'm sorry, but to broadcast it. End of story. Now, Mr. Means gets up there, and y'all, I'm not going to lie, I was kind of anticipating a little bit of comic relief from him. But he was very short and to the point, thank God. And he's like, look, I'm not going to reiterate a lot of stuff here, but the cat's already out of the bag. So he really just kind of reiterates a couple of things that Pryor's already said. They're all on the same team. They all want this to be televised. So he really wasn't going into too much depth. And, he does have a point. Look, the attention that's already been brought to this has already been brought to it. I think it's comical that he says the cat's already been let out of the bag, but it's true. Now, Mr. Wright, who is representing the media in this, he goes up next, and Judge Eaton's is basically like, look, we haven't had time to do this or that yet. So basically Judge Eaton's isn't going to really let him go into a huge argument because number one, Chad Daybell didn't get to read his briefing and things of this nature. And so he makes sure with the other people there, specifically Mark Means and John Pryor, that they're okay with that. And of course, John Pryor's basically like, well, look, we're on the same team here, so sure, I'm fine if he does a few bullet points. And he does just that. And essentially he's like, look, I just found out about this stuff last Thursday, so he's kind of blindsided by it all too. And you know, he's again agreeing with the other people. A video feed is going to satisfy the needs of the public as well as the client. And basically he's like, look, if we go after the fact to things like audio and transcripts, that's going to negate the transparency process in this. So now after all of this, Judge Eaton, he circles back around to Rob Wood. Rob Wood's like, look, you know, the Supreme Court isn't even allowing live streaming over COVID right now. So he's basically like, why should we? Mr. Pryor speaks one more time, and again he just reiterates that, you know what, this is the only way to give, you know, his client a fair, open, unbiased trial is by utilizing a live stream. And Mr. Means basically follows that up with the same type thing, and then it becomes time for Judge Eaton's to rule on this. Now he does say, you know what, look, I do believe that Rob Wood is doing this genuinely. I think that he is really trying to preserve a fair trial for Mr. Daybell, and I can appreciate that. He says, look, I'm aware of the defendant's rights to a fair trial. I'm aware of the media's right to access, you know, a trial. And he's like, this is high profile, you know, and he's like, look, the public does have a right to be able to scrutinize what is going on in a case, especially one of this caliber, you know, and he does have a point there. My whole thing is this, I do agree with that, because at the end of the day, you know, this case is huge. The nation is watching it. If we're not going to be privy to some of the things going on in this, it's just going to create a total nightmare of what's going on. He said, she said, conspiracy this, conspiracy that. So it's like, you know what, it's already been put out there. You know, again, Lori and Chad's camp is not doing them any favors as far as getting out there and just doing all these interviews and talking all this crazy stuff. So you might as well just make it completely transparent. Now Judge Eaton's basically, he begins to cite some issues from the Idaho Supreme Court in regards to, look, this is how we're operating with COVID, and these are some of the changes that have taken place. And essentially it's like, look, you know what, the trials are not going to resume again until September. You know, we have to do something in between to satisfy the needs of, you know, defendants and the public, the state, the whole 9 yards. And so it kind of comes back to, one of those options is doing live streams as to avoid having people come into the courtroom. And one of those things that Judge Eaton's originally went with and is still going with is allowing one media outlet in the courtroom to live stream, to broadcast, and one media outlet in there for photography, still photography. And so that's it. We're waiting to see, you know, who the media outlet will be, how that will go. And if that's not an option, it will be live streamed like the hearing is that we saw today. So, you know, everyone can breathe a sigh of relief. We are going to be able to watch this live. Woohoo! And so that's that. Be sure to check out my other videos for some of my coverage, as well as my thoughts and opinions on this crazy case. I appreciate you watching. I'll talk to you soon.